I'm going to talk about three things: the Paris Agreement, the Climate Change Treaty, the main one alongside the United Nations Framework Convention on Climate Change and the Kyoto Protocol, customary international law, which is also binding on states under international law. It's created out of widespread state practice, where this state practice is accompanied by a belief that it is in accordance with a customary international law rule. And thirdly, the law on state responsibility, the law about what happens when a state breaks its international legal obligations. So let's start with the Paris Agreement, which was discussed in relation to the first question. And what struck me, reflecting on this advisory opinion over the subsequent weeks, was just how very much the court has made the Paris Agreement central analytically to its overall reasoning. The court really leans into this treaty regime. And there is so much in the advisory opinion, what with customary international law and all the other applicable treaties, which include the UNFCCC, the Kyoto Protocol, the Convention on Biological Diversity, the Desertification Convention, the Ozone Treaties, the UN Convention on the Law of the Sea, the relevant human rights treaties. There's so much that you could be forgiven for underestimating the extent to which the Paris Agreement is really key. But the more I reflect, the more I realise that is the case. What the court does is it reinforces the Paris Agreement in numerous ways, including, probably most centrally, by recognising the Paris Agreement's 1.5 degree temperature target, as both scientifically necessary and legally pivotal. The world must aim for a target of no more than 1.5 degrees C of global warming over pre-industrial levels. Now, arguably, the key to global mitigation efforts lies in states parties' Paris Agreement obligations to prepare, communicate, and maintain nationally determined contributions, or NDCs, to international mitigation efforts every 5 years. So, just for example, New Zealand's first NDC, as adjusted in 2021, included a target of reducing greenhouse gas emissions 50% below our 2005 gross level by 2030. And our second NDC set this year includes a target of 51 to 55% below our 2005 levels by 2035. Okay, now Article 4.3 of the Paris Agreement says that successive NDCs must represent a progression beyond the parties' then current nationally determined contribution and must reflect the parties' highest possible ambition. Critically, the court clarified that these are not just descriptions, they are requirements of NDCs, they are prescriptive. So looking forward, it's going to be interesting to see how successive NDCs are scrutinised to determine whether they incorporate progression and highest possible ambition. And this might involve a range of reference points. So not just the headline target, but the scope, the coverage, the inclusion of supplementary objectives, etc. as well. The Paris Agreement specifies additionally that NDCs must be informed by the outcomes of 5 yearly global stocktakes, including the first global stocktake concluded by the parties in 2023. And the court observed that the 2023 global stocktake involved the governments of the world recognising that despite overall progress, parties are not yet collectively on track toward achieving the purpose of the Paris Agreement and its long-term goals. Now, another significant contribution from the court was to add here that legally, in the view of the court, states' NDCs, when taken together, must be capable of achieving the temperature goal of limiting global warming to 1.5. And the court added that the standard of performance required in respect of these various obligations is that of due diligence, and furthermore, stringent due diligence in light of what we're dealing with. That does vary for developing countries, and in light of national circumstances, that's standard. As well as setting an NDC, the Paris Agreement says states have a critically important obligation to pursue domestic measures with the aim of achieving the objectives of such contributions. And the court told us that the obligation to pursue domestic measures with the aim of achieving their objectives requires states to pursue measures that are reasonably capable of achieving their NDCs. So we have another test. Basically, states have to implement their NDCs by making plans for how to do this. And among, of course, the many tools at their disposal is using an emissions trading scheme and putting a price on carbon, which creates market incentives to bring down emissions. Turning then, secondly, to customary international law as the other major source of international law, just as vital to this advisory opinion as the climate change treaties. But customary international law obligations apply to all states, unlike treaties to which a state must be party to be bound. So, for instance, the United States will continue to be bound by customary international law relating to climate change, even when its withdrawal from the Paris Agreement takes effect. I think that's early next year. Or if the New Zealand lobby to quit Paris were to lead to such a counterproductive action, New Zealand would still continue to be bound by customary international law. So this adds importance to the court's pronouncements on customary international law. And the court articulated, as Vernon has foreshadowed, two major customary international law duties on states. One is the duty to prevent significant harm to the environment, here the climate system. And the second one is the duty to cooperate for the protection of the environment. For the duty to prevent environmental harm, the court confirmed that the required standard of conduct is due diligence, which means that states must employ all means reasonably available to them. And again, this was stringent due diligence. The court added, actually, that even activity that is insignificant in isolation can give rise to the duty to prevent. An interesting comment. Now, on the second customary international law duty, the duty to cooperate for the protection of the environment, the court said that cooperation has to be sustained and continuous. Specifically, international law requires states to cooperate to achieve concrete emission reduction targets. This is customary international law. It requires cooperation to achieve concrete emission reduction targets or a methodology for determining the contributions of individual states with respect to fulfilling agreed temperature goals. It sounds quite similar to Paris, doesn't it? It's a parallel Paris, if you like. But here's quite an interesting point. The court said that at the present stage, compliance in full and in good faith by a state with the climate change treaties as interpreted by the court suggests that the state substantially complies with its customary international law prevention obligation. Okay, so it's leaning into the treaty. If you comply with the treaty, you are probably complying at the moment with customary international law. And if you're a non-party, or if you've, heaven forbid, quit, the court says that a non-party state that cooperates with the parties in a way that's equivalent may, in certain circumstances, also be considered to fulfill its customary international law obligations. And the other key point, I think, in the relationship between these sources is the court signalled that climate treaties may not be enough in perpetuity. There could come a time when the climate situation is so severe that cooperation beyond that envisaged in our current treaty regime may be required as a matter of customary international law. I can see I've used most of my time, so I'll make one more point and then I'll leave the question of state responsibility and reparation for question time. So the final point really to make is that the court said that the customary international law obligation of environmental impact assessment applies in relation to individual activities that are particularly significant, and these have to be assessed for their impacts on other states, including their downstream effects. Now, two of the judges further clarified that this means that combustion of fossil fuels must be taken into account in decisions around production, licensing and subsidisation, and included in environmental impact assessments. We can talk a little bit more about fossil fuels later on, but I think I should probably pause there and invite the next speaker to, I was going to say to the stand, but we don't mean to the stand.